Will you win your Georgia workers' compensation case? Hello, my name is Ty Wilson. I'm a Georgia workers' compensation attorney practicing law in the state of Georgia. And a question we get a lot is, well, if I decide to go to a hearing, will I win? Well, we cannot tell you yes or no. Everything that matters when you're dealing with a Georgia workers' compensation claim is what is called evidence. And evidence is what you have that you can prove. We all know that there are certain things that happen, but if you can't prove them in a court of law, it's like they didn't happen. And so evidence is what you must base your case on. And in reality, anybody who says, yes, you can win, well, if you've got a slam dunk, yes, you can win case, you really shouldn't be at a hearing, okay? There are times when the other side, employer, insurer, may not know details for some reason, but I think for the most part, once all the evidence is laid out, they're pretty realistic in their expectations and will not drag something into litigation, typically speaking, without a reason. And so if there's something they are continuing to fight, there's probably some evidence, there may be some surveillance or video footage of you doing something you shouldn't have been doing or something along those lines. And so it's important to find that out into what is called discovery. But will you win your case? That's a complicated question. There is no guarantee that you will win everything you're seeking in a workers' compensation claim. And so for any attorney to tell you otherwise, I think is somewhat reckless. The only way you find out if you win is by going through the process. And I'll say this, a lot of times what is considered a win is also a question mark. In workers' comp, you're seeking medical benefits as it relates to your work injury, and income benefits if you've been taken out of work for more than 7 days or are on light duty or out of work completely for more than 7 days. If you're on light duty, the employer cannot accommodate your restrictions. Okay, will you win all of that? Well, the question is, what evidence do you have? Do you have work status reports that show that you're out of work or that you're on light duty? Do you have a name of someone at the employer's office that says, hey, just stay home. We can't accommodate your light duty restrictions right now. We need somebody who can do 100% work. That does happen. Doesn't always happen in writing. And so the more evidence you have in support of your contentions, the better chance you have of winning. But as far as slam dunks, well, those are far and few between. They are out there, but once again, if something is a slam dunk, it doesn't need to be on a hearing calendar. So it's important that you look at all the evidence or lack of evidence and what can be inferred and looked at. And then how does that judge receive that information? Because in a workers' compensation claim, the judge is the person who makes that decision. It's not a jury. There's no juries in workers' comp. It's administratively based, so it's an administrative law judge, and they're listening to the evidence. And then they see the documents that get tendered into evidence. And if there's anything else in evidence, well, the judge will listen to that, and then they'll listen to the testimony at the hearing. And then they make their decision. So it's about what's on the record, it's about the evidence, and it's about what can be proven. Hope that information has been helpful, and we'll see you on the next video.